and welcome back to Facts or Frauds. Make sure you hit the thumbs up button, you're subscribed, and ring that bell for notifications so the next time I premiere a video, you can be in the live chat with everyone else and leave a comment in the comment section, tell them what you think. Now let's head to Fulton County, Georgia, where a sovereign citizen tries the script for the very first time in front of a no-nonsense judge.
What you are witnessing is real. The participants are not actors.
Bishi?
Kapuma.
No, your last name.
I am Kapuma.
Okay. What's your last name? Wimbishi?
Kapuma is my last name.
Okay. So what's the first one then?
Mwembeshi.
Okay, there you go. They have it reversed. Thank you. Okay.
Yes.
Yeah, okay.
Oh, they
So-
have it reversed? Okay.
So it's Wimbishi Kampuma.
So your name is, like, your last name is Kapuma then?
My last name is Kapuma.
Okay. We'll make sure didn't want to destroy it, too bad with my accent. So I
Okay.
guess they need to know that because they have it reversed.
Yes, and because of that, it's an invalid contract.
Well,
Because
not
my
necessarily. That's just a typo, but
yeah, but according to this,
We're just kind of getting started here, okay? So I'm just trying to pronounce your name right. That's basically all that is, okay? All right, so this is number 122 CP 214772. Here it's Kapuma Wimbishi, but it's actually Wimbishi Kapuma. So I think they could probably modify that at the jail. I guess y'all want to take care of that. Okay, so we got 285 days without indictment. He had a Ferretta hearing and he's representing himself. So it's aggravated battery, willful obstruction of a law enforcement officer with a felony. Officer, if you could raise your right hand for me. You swear affirm testimony you're about to give is the truth, whole truth, nothing but the truth.
Yes, ma'am.
All right. If you state and spell your name into the microphone for the court reporter, please.
Yes, ma'am. My name is Patrick Marsh. First name is spelled Patrick. Last name is spelled Marsh, Marsch.
Okay, Officer Marsh.
Okay, so one second. So, sir, what this is a preliminary hearing, okay? It's just to establish that there's probable cause. So the DA is going to ask some questions and then you get to ask follow-up questions, okay? All right. So go ahead, Ms. Fields. And this is Ms. Kelly Fields. She's one of the assistant district attorneys. Go ahead, Ms. Fields.
Thank you, Judge. Officer Marsh, can you tell us, you already told us your name, but can you tell us where you work and what your title is?
Sure. I work for the City of Atlanta Police Department and my title is rank as an officer.
Okay, and are you post-certified?
Yes, ma'am, I am.
Were you post-certified on the date in question? On December the 15th of last year?
Yes, ma'am, I was.
And can you tell us what happened on that day?
Sure.
Regarding Mr. Kapuma.
Sure. So on that day, I was dispatched to a call at 1776 Peachtree Street. There was a fight going on that apparently was going on the fourth floor at the clubhouse. We had received several calls as well, arriving on scene from a passerby saying that there might be a weapon involved. So I immediately called for backup. Officer Jones and Officer Easton arrived on scene to assist me. We go up to the fourth floor. We go to the right where the clubhouse was, and we found a white male victim named Johnson that had a gash to his forehead. We had asked him what had happened, and he said that he had been knocked out by the defendant.
When you say knocked out, can you tell us what that means?
Sure. So apparently the defendant said that they had noticed, the victim had noticed the defendant acting in a strange manner. And when he went to put his hand on his shoulder to ask if everything was okay, he advised that the defendant hit his upper right eye with a closed fist, causing him to go to the floor and was unconscious
Okay.
during that time.
So he was unconscious.
He was unconscious, but he was not unconscious when we arrived on scene. But
You were gaining consciousness.
yes, ma'am.
Okay, now you said that this happened at what address?
Peachtree Street.
Is that in Fulton County?
Yes, ma'am, it is.
And can you identify the defendant and describe what he's wearing and where he is in relation to you?
You can stand if you need to.
Oh, I can see it on the screen here, ma'am.
Yeah, that's okay.
Thank you very much. Yes, I can see the defendant. He is wearing a blue Fulton County uniform with a white shirt under it.
Okay. Let the record reflect that the witness has correctly identified the defendant.
All right, noted.
So we talked about that Mr. Kapuma rendered this man, Mr. unconscious. And is that the basis of the aggravated battery?
Yes, ma'am. So under the code section of 16-524, the elements of the crime for aggravated battery indicate that you render a limb unconscious. And so with the brain being a member of the body, we decided to go ahead and move forward with the aggravated battery because the brain was rendered useless during that time.
During the time that you was unconscious?
Yes, ma'am.
Okay, and did EMS arrive?
I'm sorry?
Did EMS arrive?
Yes, ma'am. Mhm.
And what happened with that?
I'm sorry?
What happened with, excuse me, I was talking
Okay,
about,
all right.
what happened with that?
So during the incident of while we were trying to get the defendant into custody, he was resisting myself and numerous officers. So one of the officers on scene had to deploy a City of Atlanta issued taser in order to try and get him into custody. And during that time, that's why we called EMS to go ahead and have them remove the prongs as well as go ahead and check his vitals because he did appear to be acting in some type of irregulated manner, whether it could be on, just having a mental breakdown or something of some nature, but he clearly needed some medical attention, which is why we go ahead and called EMS as well.
Was EMS called for Mr.?
Yes.
Okay, did he allow them to treat him?
He did not need EMS. When we got there, we asked him, he said that he did not need it. Some of the witnesses and the friends who were at the event were tending to the victim.
Now, with the charge of willful obstruction, was there any violence or offering of violence or just resistance?
There was no offering of violence. There was just actively resisting when giving verbal commands.
Okay. And he said that Mr. Johnson was concerned about how Mr. Kapuma was acting.
Yes. So
can you describe how he was acting and what you were told?
yes. So what I was told by the victim is that at some point this was a company event that was going on, and during the course of the event, at some point, the defendant had put, according to Mr. Johnson, had put his AirPods into his ears, and he started being very incoherent, saying a whole bunch of stuff that Mr. Johnson didn't understand. And according to him and several other people at this event, they had never seen the defendant act in this manner before. And so when Mr. Johnson went to put his hand on the defendant's shoulder, that's when the defendant acted out.
That's when the altercation happened.
Yes, ma'am.
Okay. Do you have any other statements you'd like to make to the court regarding these two charges pertinent to this case?
That's pertinent to this case, no.
Okay. That's all I have for right now. It's your witness, Mr. Kapuma.
All right, Mr. Kapuma.
Okay, thank you, Your Honor. I have a question, right? Because according to this warrant, first of all, it shows here that he was called for a fight.
Okay, step back. What questions do you have for the officer?
Yes, that's who I'm asking, because I can't see him, so.
Oh, okay.
You can't see him on your.
Okay, so he was called in for a fight, right? So according to this statement, Keith Johnson put his hand first on me. Then I reacted to that with a punch. It doesn't show how hard he pushed my shoulder. It was in a hostile situation because I was at a party.
Okay, so stand by, Mr. Kapuma. What is your question?
So
Who, what, where, why, when?
so in that situation, who was the aggressor in that situation? Because he put his hands first on me.
Just ask a question.
Mhm.
So, okay, so based on when we spoke to the witness, I had the witness actually show me how he placed his hand on the defendant. And Mr. Johnson said he basically just placed his hand in a almost caring way, just a concerning way on his shoulder to see if everything was okay. And that's when the defendant acted out and hit the victim.
Okay, next question.
So is there a written signed statement from the witness about that incident to describe what you're saying so that they sworn like a
Hold
sworn
on.
a sworn affidavit?
Who, what,
That's-
where, why,
I'm
when?
gonna have to object. Compound question. Can we?
All right. So you ask a question like this. Do you have a written statement from the victim?
Do I have written a statement? No. Do I have it on body camera? Yes.
Okay, next question.
So there's body camera for the entire event from all 5 officers of what happened.
Yes, so my body camera was activated from the time I arrived into the parking deck before I made contact with anybody up until the very end of the incident as well. So there is a full body camera footage from start to finish, including a body camera footage from each of the officers during the interaction as well.
Okay, so from my recollection, right?
Whoa. No. If you want to say something, but you have to ask him a question. So she asked him questions, so you ask follow-up questions to what she asked.
Okay. So based on the body cam video that you're saying, does it show that I was tased until I passed out or died and then had to be resuscitated?
So the body camera footage from Mr. Jones, I would appear because Mr. Jones is the one who tased the defendant, but the defendant at no point in time lost any consciousness or at any point in time had to be resuscitated by Grady.
Okay. Next question.
So this, I understand. So when will I be able to see the body cam? Because I haven't had a chance to look at it, see what exactly happened on that event.
All of that gets turned over at discovery, but allegedly you were there. So what's your next question for him?
According to the law, which I'm new to, did I give consent to be arrested? Because according to the
Judge, counsel, or I don't know if I should call him counsel, but
That's actually,
he's been testifying, and so we object to testifying.
so did you give consent to be arrested? Did he give you his consent to be arrested?
Your Honor, he did not consent to get arrested, but based on the elements of the crime, we had enough probable cause to make the arrest.
Okay, next question.
was based on my understanding.
No. Next question. If you want to say something later, you can, but what's your next question for him?
Okay, so in terms of the resisting arrest, is it not my right not to resist if there's no jurisdiction over me?
No! You said stand up?
No, I told him to stand by. I didn't know if you had an objection.
Yes, I have a judge. I understand you're giving him leeway, and I understand the reason for that. However, counsel has been not asking direct questions on cross, and he has been testifying numerous times. So we just have an overall objection to that testifying that's been happening from pretty much from the start of this questioning. So we ask that he ask direct questions, not have this kind of commentary in addition to his questions.
So what you're asking is him to draw a legal conclusion. So
Yes.
What's your next question? What's your next question for him?
Because for me, it's mainly about consent and jurisdiction.
Okay, hold on.
Mhm.
But that's argument. But what question do you have for him?
I don't have any questions for him.
All right.
Okay.
Anything else with the officer?
I do have some redirect.
Okay, go ahead.
So, officer, I know I was calling this, that was my mistake. I meant to say the correct, and the correct victim's name is Johnson. Is that correct?
Yes, ma'am.
And Mr. Johnson was hit by Mr. Kapuma.
Yes, ma'am.
Okay, and that's all I have.
Thank you, ma'am.
All right. Any follow-up based on those questions that she asked?
Basically, not really.
Okay. Thank you,
Okay.
officer. Stay safe
Thank
out
you.
there.
Thank you very much, Your Honor.
Have a
Stay
good
safe as
day.
well.
All right. Go ahead with the argument. Let's hear from the state.
So, Judge, I believe that we have met our burdens for our probable cause for the first charge, which is aggravated battery. The defendant did render Mr. Johnson's brain useless by, rendering him unconscious for a period of time, where he did, fortunately regain consciousness, but he was rendered unconscious for a little while after he was struck by Mr. Kapuma. And as far as the willful obstruction, we understand there was no violence or offering of violence against, the officers and Mr. Marsh and other officers at the party. So we suggest that should be a misdemeanor and not a felony. But other than that, we think there's probable cause for both charges, as just stated by myself and the state.
All right. Do you want to respond? Now, this is where you give argument. So now is your chance to give argument.
Okay, so first of all, based on just this warrant, my name is spelled in capital letters. It's in reverse. From my understanding of law, that's a name of a strawman or a corporation. So that does not apply to me. Because it says the accused is capitalized, that's a corporation, and a strawman, which has no bearing to me. And in this matter, I do not give consent or agree to represent my strawman in this case, because I'm a sovereign being. I'm an internationally protected person. But at the same time, from my understanding of the constitutional law, which is the law of the land, I have to give informed consent or sign a contract in order to be judged or in order for the case to move forward in this regard. Because according to the Fifth Amendment, one of the things is before I can be arrested or detained, I have to be indicted. I have not been indicted. One, I did not give consent to be arrested or to be tried under this jurisdiction because I operate under common law. That's my jurisdiction, common law, God's law, and natural law. I do not consent to be tried by the Admiralty law system, which is evident by the gold fringe on the flag and the eagle at the top, which shows this is a maritime law, which is commercial law. And as a sovereign being, I report to God. God is my judge. As it relates to how I interact with other humans, it's only by common law, which is when I injure a human being, and that's also dealt with in the common law court. And based on my international status, because I am a king where I come from, an internationally protected person. So according to Executive Order 143107, which is human rights, this is a violation of human rights. From my understanding of the law and my rights, my unalienable rights, if I have not given consent to be tried or to be held or to be detained by or given jurisdiction authority to the officer, and they arrest me, that's a kidnapping, and I'm being held hostage right now. Because according to the Constitution, I have to be indicted before I can be detained. That's according to the Fifth Amendment rights. And the Constitution, from what I understand, is still the law of the land. Because according to the Supremacy Clause, every case, if I can cite one case, which is the Madison versus Marbury, every case in that situation, which cited that case as into the legality of the constitutional unconstitutionality of any situation, was overturned by the Supreme Court.
It's false.
So in this situation, yes, I did react to Johnson putting his hands on me. Though the witness may have said something, they might have been friends with Johnson. I reacted to a situation. For every action, there's an opposite and equal reaction. He touched me first. I reacted. When the officers came to arrest me, I didn't do anything wrong but defend myself. I've been charged with willful obstruction. According to the Constitution, according to my unalienable rights, according to my human rights, I've got the right to defend myself. If I put up on anyone over here and just touched you on your shoulder without even asking for your consent, some people will tase me. The officer will shoot me. But if the same thing happens to me, he touched me first. I reacted off of that. That's self-defense.
Okay, anything else? All right, so I'll find probable cause on the aggravated battery, and then the misdemeanor, the willful obstruction will be reduced to a misdemeanor. And we'll go ahead and address bond. Let's see, because right now, bond, let's see. Right now, as of June 27th, there is a $30,000 good bond.
The defendant has 3 cycles. The defendant's last arrest was May the 9th, 2021 in Dunwoody, Georgia, for Terroristic Threats Act and possession of a firearm during commission of a felony and criminal attempt to commit a felony. There was no disposition for that arrest, and there are no convictions listed in the GCIC. Nothing in addition, Your Honor.
All right. Go ahead with your bond argument, sir.
First of all, it was just a punch, and I don't see how it can be a felony. And if it was pretty much a misdemeanor at best, because one, it was self-defense, misdemeanor at best, the maximum is 1 year, and I've already done 10 months in jail pretty much for one punch in self-defense, in defense of myself. At the same time, I feel like I have already done the time for this.
Okay, anything else? All right, what says the state?
Judge, the state is inclined to keep the bond as is because the severity of the injury that took place. Yes, Mr. Johnson, he was rendered unconscious. The punch that, counsel was trying to minimize was very severe. The punch took him out. So because of that, and then him resisting arrest, we do believe that the $30,000 bond is sufficient.
All right, so it'll be no further contact with Johnson. Stay away from Peachtree Street Northeast. You're going to have no drugs unless prescribed, no alcohol, no weapons. It's going off my bond order of 627. You have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you'll be working. Are you still going to live in Roswell, sir?
Sandy Springs.
Sandy Springs, okay. All right. So just supply a good address to the jail upon release. So 15,000 count one and count two is reduced to misdemeanor, so that'll be 5,000. So $20,000 good bond. Best of luck to you, sir.
Do you think this show is educational? Yes, it'll drive people to read books.
And thanks for joining Facts or Frauds. Make sure you hit the thumbs up button, you're subscribed, and ring that bell for notifications so the next time I premiere a video, you can be in the live chat with everyone else and leave a comment in the comment section, tell me what you think. And a huge shout out to our channel members, Robert Morley, Andy, Chris Kelling, Got Us with Tooth, Pat's Cats, Pedro Whack-A-Mole, Westside Girl Reacts, Jason Heaton, Shawn, OldFart, Drew B, CW1960, and Butcherbird. If you'd like to become a member, just hit that join button right next to subscribe. Or click on it in the link in the description. And if you've made it this far, why not hit that thumbs up? Subscribe if you're not subscribed already. And if you'd like to support the channel, hit that super thanks button. And I'll see you soon.